Welcome to the NCAI Policy Research Center monthly webinar series. We'll be starting in a minute or two. Thanks for joining. Hello, I'm Dr. Yvette Rubidoux, and I'm the Director of the Policy Research Center at the National Congress of American Indians. Welcome to our NCAI Policy Research Center webinar series. Today, we will focus on intellectual property rights in biomedical research. This webinar features speakers from the National Institutes of Health, or NIH. We're so glad you joined us today, and I encourage you to watch for our monthly webinars. We try to hold them monthly, and they will focus on how data informs policy and will feature a variety of topics and various guest speakers from time to time. I encourage you to join our listserv for announcements by emailing research@ncai.org. We also announce our webinars on Twitter and on our website. If you missed any of our webinars, the recordings are usually available on our NCAI YouTube page or on our website, www.ncai.org/PRC under Events and Webinars. Here's an overview of today's agenda. I just provided a welcome, and Dr. David Wilson from the NIH Tribal Health Research Office will introduce the speakers today from the NIH Office of Extramural Research and the NIH Office of Science Policy. Once the speakers are done with the presentation, we will reserve time for questions at the end. Before we get started, I'm going to review a few housekeeping items and let you know how you can participate in today's web event. So this is a depiction of the GoToWebinar attendee interface. It is made up of two parts: the viewer window on the left, which displays the presentations, and the control panel on the right. I'll quickly navigate how to use the control panel so you can readily participate in today's web event. By clicking the orange arrow, you can open and close your control panel. And then here's where you will find all the information about your audio connection. We recommend dialing via phone rather than the computer, as it tends to limit feedback. To dial in, you will find the number and access code here, along with your unique audio PIN. As you can see, all attendees are currently muted in listen-only mode. At the end of the presentation, we will open for Q&A, or questions and answers. At this time, please submit your questions via writing them in the question pane. As a reminder, today's webinar is being recorded. After the event, you will receive an email with a link to a short evaluation, and the recording will be available soon on our NCAI YouTube page and our PRC website in a couple of days. At this juncture, I'm happy to introduce Dr. David Wilson, Director of the NIH Tribal Health Research Office, who will introduce the rest of the speakers.
Great. Thank you, Dr. Rubidoux. It's a great pleasure to be with everyone today. We're really excited about having this important discussion. Today's talk will be an introduction on inventions, patents, and the NIH intellectual properties as they apply to biomedical research. We are happy here to be at the Embassy of Tribal Nations today with a beautiful spring day outside. I'm Dr. Dave Wilson, and with me I have Dr. Juliana Bloom, who is the Deputy Director of the NIH Tribal Health Research Office. And then we have Ann Hammerslaw, who is the Director of the Division of Extramural Inventions and Technology Resources at the NIH Office of Extramural Research. And then we also have Dr. Mark Rohrbaugh, who is the Special Advisor for Technology Transfer at the NIH Office of Science Policy. And also joining us in the room here, we have Dr. Jay Rivieza from the Throw Office, and also Mr. Ted Keene, Health Science Policy Analyst. So this is a really important discussion. It's an introductory discussion that we would like to have, and this is an introductory presentation leading up to the NIH 2019 Tribal Consultation that will happen at the NCAI Mid-Year Conference in Sparks, Nevada, and our consultation will happen on June 24th of this year. So we are really excited to have this initial conversation, and right now I'd like to turn it over to Ann and Mark.
Hello, everyone. Both Mark and I are very happy to be able to talk to you. My only regret is I can't see you, and I like to see faces and see your questions as they come. But nonetheless, Mark and I are going to be giving an overview of what technology transfer and intellectual property, what it all might mean to you, and to those who you might be working with or collaborating with in research. The first stop is on slide 3, and I put up the NIH mission. If you have not looked at your mission recently and you're venturing into technology transfer or patents or inventions or collaborations, you might want to just rethink your mission to see if it captures your goals of technology transfer and research collaboration. The NIH mission is there on slide 3, and it's not an unusual slide for our contractors and grantees to have something similar. As I said, we're going to be at the 10,000-mile, 15,000-mile guidepost and talking about technology transfer, so that we're all on the same foundation in the same spot. When we talk about technology transfer, we're talking about the movement of information and materials or technology in any form from the creator of that technology to a third party. It's the transfer. On the next slide, you will see some examples of technology transfer when you're talking about data or research, publications, inventions, and patents. We'll talk about patents shortly, but issued patents are all become public. So it's a vehicle to transfer information also. And before you engage in many of these activities, you want to, again, if you haven't checked your policies recently, you might want to check your policies and the guidelines and your goals as to what you want to accomplish when you enter into some of these agreements and file a patent. What are your ultimate goals and your policies for your researchers? Okay, we're stepping down one step now from the broad concept of technology transfer, and we're going to be talking about what is intellectual property. Well, it's very simple. Intellectual property is a creation of the mind. That's it. That's all it is. It's not a mystery. Some intellectual property can be protected by laws, U.S. laws or international laws. There's patents and trademarks, and we're going to be talking about patents today. There's copyright, trade secrets, publicity, etc. And intellectual property is protected in various forms by these laws. The intellectual property systems and laws aim to foster an environment in which creativity and innovation is created, it's supported, developed, protected, all with benefits to the public. Because once this information is protected, the intellectual property is protected, it does become available to the public through various means. Next step down from technology transfer intellectual property is, what do we mean when we're talking about an invention? What is it? Well, it is a new scientific or technical idea. I've given the citation for the U.S. Patent Code, but very simply, it is something new. It is not obvious. It could be a device, it could be a method, a composition, materials, something substance, or it could be a process of how to do something. An invention could be a combination of any of these. It could be a material and then how to use the material or how to create the material. This definition of what an invention is and then what can be patented changes over time, and Mark is going to be talking a little bit about that, and that's because of Supreme Court decisions or new research ideas or materials. Again, what is an invention? As I said, it is protected by various laws, U.S. patent laws or international patent laws, as shown on the slide. Once you have an invention, your next consideration may be, should I protect it? And how are you going to protect an invention? You protect it through a patent or applying for a patent. Very simply, in very broad strokes in defining a patent is the grant of a property right to the inventor. Note here, the first property right goes to the inventor. Your agreements with your researchers or inventors would most likely require them to assign their rights in their invention to you as an entity. But the invention always, and the patent is always, the inventor's names always appear along with who owns the invention, which would be the employer of usually the employer of the researcher. In the United States, a patent is issued by the U.S. Patent and Trademark Office, and for a biomedical patent, it's anywhere between 2.5 years, to about 3.5 years. Which is a great improvement from a few years ago when it was 5+ years. Now, a term of a patent, to file a patent, a U.S. patent, it's going to cost you money. And usually a U.S. patent, just a bare bones U.S. patent, is going to be anywhere from about maybe $15,000, but usually it's going to be in the area of $20,000 to $30,000 by the time you're done and by the time you get your patent. It is expensive. So what do you get out of that, right? That's a lot of money, so what do you get? Well, the term of a patent, of a U.S. patent, is 20 years from the date you first file an application. So it lasts for 20 years. In some circumstances, it can be extended because of actions in the patent office, or if this is an FDA-approved product, extensions can be given. Very important to note, a U.S. patent is not valid everywhere in the world. It is only valid in the U.S. or U.S. territories or U.S. possessions. And once a patented, the patentee must enforce the patent. It must enforce it to protect it. And we're going to talk about the rights in a second. For U.S. patents, there are 3 major categories of patents. One is called a provisional, then a non-provisional, which has 3 types, a utility, a design, or plant patent. And then a third type is our types of continuations or divisionals or continuations in parts of your originally filed patent application. Again, we're keeping this at a very high level and won't be going into the distinctions between these patent types, but just to know that there are various types of patents. Okay, so you spent your $30,000 or your $15,000 and you've got your 20 years, but what does that give you? Well, it doesn't give you a lot. It only gives you the right to exclude others from making, using, offering for sale, or selling the invention, or importing the invention into the United States and its territories and possessions. A few minutes ago, I talked about you have to do something with your patent. You have to protect its use. You're not given an exclusive right. What you're given is an exclusive right to exclude, not to use, because there might be other owners of patents that if you develop a product on your patent, you might need the rights of someone else who also owns a patent. So you have the right to exclude. So what does a patent protect? It protects an invention, and that invention must be novel, useful, or non-obvious. Those are the three important criteria that are considered by the patent examiners to obtain a patent. But on the other side of that coin of what can be patented, what cannot be patented? Well, laws of nature. Anything naturally occurring, genes, plants. You can protect genetically modified products, physical phenomena. Abstract ideas also cannot be protected through a patent. A literary, dramatic, musical, and artistic works cannot be protected by a patent. They can be protected by other forms of legal protection, but not through patents. Inventions which are not useful, and always in speaking as in law school or in a patent attorney, they're always going to bring up to you like a perpetual motion machine cannot be protected, or offensive to public morality. Mark?
The Supreme Court of the U.S. has made some decisions about patenting naturally occurring substances and materials in the last 10, 15 years that has narrowed the ability to get broad claims on these naturally occurring materials. So, for example, in the past, animal or human DNA sequences could be patented, but now they can't, whether they're from bacteria, plants, animal, or human, to the extent they're naturally occurring. If you take different pieces of DNA and put them all together in a new form, that can be patented, but not, say, a sequence of a gene from a human or an animal or a plant. Also, naturally occurring proteins and chemicals cannot be patented as they exist in nature. So the example I gave is if somebody wants to study peyote cactus and understand what chemicals might have activity in humans, let's say they find a new chemical or protein that reduces anxiety, and they are interested in making a product out of this for treating humans. If the chemical is exactly the same as when it came out of as that which is found in the plant, then you can't patent that chemical. If you make some change to it, a chemical change, or you have it in the form of a tablet or a pill, or somehow modify it so it's not exactly the same as how it occurred in nature, then you might be able to patent that. Or a method of using it, say a method of using it to reduce anxiety or whatever condition in humans. Also, associations between, say, genes and the result they have in the human cannot be patented. This general idea that, say, if you have this gene, certain genes, you're more likely to have diabetes or cancer or what have you, or there's a certain protein in someone's blood that could predict the incidence of a cancer. Those general similarities and associations cannot be patented. But if somebody developed a very specific test, with using a piece of equipment to analyze something that's really tangible and not a broad association, you could patent, if it's new and not obvious, somebody could patent that, for example. Next slide. So Anne spoke briefly about the patents being a public disclosure. Ultimately, you need to, patents must disclose the full invention, and as the term we use is teach. It must be able to teach others how to use the patent. So one, others can test it, try it, may not be able to make a product, but they could test it and toy with it. Maybe they can find another better way of doing the same thing. And after the patent term ends in 20 years, anyone would be free to use it, barring other legal or restrictions. It's important then, because a patent has to be novel and not published or disclosed publicly before. If someone has potential of sharing information about detailed information about an invention, or in a discussion you think a new invention might arise, it's important to protect that through confidentiality disclosure agreements. So you have an idea that how a traditional plant, mineral, animal can be used for a certain effect. You might want to, if you're talking with a scientist about how you might develop that further, it's probably a good idea to have a confidentiality agreement. So that discussion and any would not be considered a disclosure, and therefore no longer make the invention novel. Next, please. Anne?
The next two slides sum up the process of beginning with an invention and going through the commercialization process that Mark and I have talked a little bit about. So on the first slide, the inventions and patents in the award process, what is important to keep in mind is that inventions and patents always occur post-award. So you need, for the federal government, this is when you're being funded by a sponsor such as the federal government, an invention and patent always would occur after the award occurs, but during the research. And usually it's not known that an invention has occurred until really when you're doing your final report and summarizing your accomplishments in your research. On the next slide, again, it's just another visual about the research and invention process. On the left-hand side, you can see the NIH would award funds. The recipient or the grantee receives them. And then there could be an invention. Again, it could be the research funded could be 10, 15, 20 years before the invention really is an invention that can be protected under U.S. laws. And what is important is that once a patent is issued, there is usually, I said there was 20 years of life in a patent. Subtract the 3 years it took to get a patent. Now you're up to 17 years. So usually following a NIH grant of 3 to 5 years, you're talking about continued responsibility for an additional 17, 18 years after the award has ended. And during that time, as you can see on the right-hand side, during that time, you're working with others to develop the invention and patent into a product, maybe testing it in animals or humans, working with someone, an entity that might commercialize it or further distribute or transfer this patented idea. But it's a long-term commitment. Okay. In addition to U.S. patent law, there is another form of statute and regulations if you are receiving federal funding, and that's called the Bayh-Dole Act. It's a statute with accompanying regulations, and it applies to almost any federal funding that you might receive from any federal agency, not just NIH. On the next slide, Bayh-Dole came into existence in 1980, And it wasn't until April of 2018 when it had substantive revisions. So since 1980 to 2018, it's been intact. There have been no substantive changes, and it has worked well for universities, industry, government, and all researchers and entities who are commercializing products. The Bayh-Dole Act has some policy and objectives. Again, it applies to almost any funding that you would get from the federal government. And it's to use the patent system to promote the utilization of inventions arising from federally supported research and development. Before the Bayh-Dole Act in 1979, the U.S. government owned all the inventions that were being made with the use of federal funds. Those inventions and patents rarely got used, rarely were transferred for the public good. And therefore, in 1980, in sensitivity to the U.S. Commercialization, that's the reason why the Bayh-Dole Act was created. So under a federal funding, the grantee, the recipient of the funds, owns the invention. You have the responsibility to protect it. You have the responsibility to use it, to further develop it. And if you decide during that process of those many years that we just talked about, you can waive your rights back to the government. And for NIH, we would make them, unless our intramural research program could use them, we would 99.9% of the time put the information in the public so the public can use it. Okay. Again, as I said, it applies to almost all federal funding agreements. And the Bayh-Dole Act, when you take a look at it from the citation I gave, it refers to a contractor. But a contractor in the Bayh-Dole Act means any person, small business firm, large for-profit corporation, or any organization which is a party to a funding agreement with the federal government. Well, I alluded to this recipient rights and responsibilities. If you decide you want ownership of this invention, your responsibilities would be to protect it, use it, make it available to the public in the form of a product if that's important and can be done. And also throughout this process, there's a responsibility to notify the federal funding agencies, such as the NIH, as to what you're doing. Did you file for a patent? When did you file for it? What's the patent number, et cetera? And that would last for the life of the patent. And there's an electronic database called iEdison for which all contractors and funding recipients have access to it. The next slide provides additional information about the Bayh-Dole Act. You may have heard about it before. You may have had your own inventions developed under federal resources. And again, it applies to all federal funding and not just NIH's funding. Mark?
There are two other issues I want to conclude with. One is human subjects, that is, people who participate in research involving, in their participation in research of testing new ideas, new treatments, new manipulations for health purposes, for example. And the final one is data and data sharing policies. So let me talk briefly about human subjects, people who are asked to be engaged in a research program that involves their personal participation as a test subject. So there's something we call the Common Rule that was issued in 1974 and was updated last year. And it's to describe the expectations and requirements for compliance in standard protection of humans involved in research. It deals with oversight of research by institutional review boards or organizational review boards, and addresses consent issues. that the person understand what they're submitting to and how the results may be used. So informed consent in particular is very important when we think about the final use of data or materials that are coming out of a research program involving human subjects. So informed consent is the process in which the person conducting the research, say a physician or researcher, informs the people participating as to what the procedure is, what are the risks involved, assuring that the patient understands and consents exactly to what will be done to them, and what the risk might be, so that they can be informed and therefore decide whether to participate or not. So with respect to the results involving data or human subjects, it governs their use. In the years past, the language was very broad. It basically might say that the results might be used in research. Well, I think we have a much greater appreciation for how people want to consent or review how the materials or data will be used. And so, especially under this new update to the regulations last year, it encourages more specific language as to how that might be used. Could it be used for any broad research, any kind of research, including possibly by a company to commercialize a product? Or is it restricted in some way? So it might be for medical research, but not, for example, for genealogical research. So the informed consent is a way to not only inform, but also inform the patient, the person participating, but also clearly allow the patient or the organization that's working with the patients to clarify and possibly restrict the uses to what that participant is willing to provide. So, for example, as I mentioned, so if something could be used to research, the patient and the group involved wants to limit the use of the data so that it cannot be used in genealogical research, that could be specified in the consent form. Or if it's diabetes research and they don't want it to be used for heart research. Whatever it is, that can be specified and negotiated in advance for with the Institutional Review Board as to what that language would say or not. Finally, I want to discuss briefly data sharing policies. So there's all kinds of data, as you can imagine. There may be data from testing, from studying animals. There might be data from collecting information about, next slide, please. Next slide, please. So there might be data in terms of diet or exercise or other habits that someone might have that affect their health. So the general policy for genomic data, that is data about someone's genes and their DNA, when it's broad, not just one single piece of DNA, but the broad elements of their genome, of their DNA, the overall policy is to state that the greatest public benefit will be realized if large-scale genomic, and I might say anonymized, data are made available in a timely manner to the largest possible number of investigators for further research to ultimately benefit humans. Might be insights that are useful in terms of how we interact with our environment, what chemicals we avoid, what diets promote healthy living, things like that. For human data, there are special protections in which the data are made under terms and conditions like the informed consent. So they must be consistent in terms of providing. So as I mentioned, if there's a restriction on their use in the informed consent, then the sharing policy for human data would take that into account and limit and restrict the use of that data for only those purposes that have been provided by the participant. So the genomic data sharing policy at NIH sets these kinds of expectations and responsibilities for institutions and researchers that collect broad data about human genomes. The scope applies to all NIH-funded research, generating large-scale, not just human but non-human data as well. And I will, next slide, please. In thinking about human data and how it's used, there are generally two types of access. So one would be unrestricted. So if the information, the genomic and genetic information was provided without restrictions on its use, in an informed manner, then it's unrestricted. You would de-identify the data. So maybe it's 100 different individuals who are nameless, and it's a mixture of all of their information together in one site in which they agreed that it could be used in an unrestricted way. There's also controlled access, particularly when there are restrictions in the informed consent of how it can be used. Those examples as I gave, in that way, the access might be only provided to people who agree, researchers who agree to access the data from a repository, data repository, with those restrictions, that they would not use it to try in any way to identify the people that participated and not use the data in certain ways, only use the data in certain ways that were permitted. Next slide, please. There are policies, I don't need to talk in detail about them, but just to mention and provide these links that of NIH policies for data sharing and rights in data and public access policies. Next, please. And on this website link, the NIH sharing policy for with policies and examples of sharing plans, the kinds of things when someone submits a grant application and certain conditions, certain types of data that is planned to be collected and utilized, they must provide a plan as to how that data will be shared, what restrictions, if any, where it will be deposited and shared, whether it's data or, say, a model mouse that's used for a study or whatever it might be. So I'll leave it at that, and thank you all very much for your attention, and we would very much like to entertain questions and answer them the best we're able.
Great. Thank you, Mark and Ann. We really appreciate that. And as you've heard from the presentations, the concept of intellectual property is very complicated. The NIH Tribal Advisory Committee first recommended that tribes hold consultation on this topic since it's a key area of concern for tribes who are either currently or considering participating in biomedical research. And with that, we hope you join us in person June 24th in Sparks, Nevada for the NCAI mid-year conference, or you'll be able to join us remotely. When we post the announcement flyer for this consultation, there will be an opportunity to join remotely through a webcast, or by phone. And also, one last thing is, if you can't think of any questions now, please submit any questions or recommendations for the upcoming consultation to the Throw office through our email address, which is NIHtribalconsultation@nih.gov. Again, one more time, that is NIHtribalconsultation@nih.gov. And then on the screen, we also have contact information for Ann and for Mark. For those of you who have not interacted with the NIH before, we are all about acronyms. So you can see that Ann has her acronym of her office up there, DETR, which is the Division of Extramural Inventions and Technology Resources. And then we also have the general contact information for the Tribal Health Research Office. And with that, I will turn it over to Dr. Rubidoux for questions. Thank you.
Thank you to the speakers. I think my brain officially hurts right now. But this was a fascinating presentation. I think that it's timely because a lot of tribes are developing their policies and procedures and tribal laws around research oversight, and they are developing things like research review boards and IRBs, and are really wanting to know what do they need to make sure that they protect themselves from in the research review process. And I thought it was interesting on the slide about making sure you ask about whether there's potential commercial use for something, which gets into the whole issue of whether there will be a patent and whether the tribe needs to be involved in that. You mentioned, I'm going to take questions from the question pane in a minute. I'm just going to ask the first question. So everybody in the audience, if you can type your questions into the questions pane, I'll get to them as soon as I can. Let's say there's a tribe that is reviewing a research application or proposal from a researcher who wants to do research with them. And you said that the patent basically doesn't give the ownership to the individual researcher. It gives the ownership to their institution where they are employed. So what do you recommend for tribes who are reviewing applications from researchers that want to do research with them? What should they put in there if they want to be able to own any potential future patents or be a part of any future patents?
Very good question, and it can get complicated in the answer. So this is Ann, and I'll give it a shot here. When you are considering whether to enter into a collaboration, it is usually the two entities that are going to be signing the agreement. It would be your tribe and another entity's research university. So maybe it's the University of Washington and your entity or your tribe. It will say in that agreement that the inventorship of any subsequent patents or inventions that are developed during that research would be owned by the employer of the inventors. So it would be owned perhaps jointly. There might be joint ownership with the University of Washington and your tribe. Your policies outside of the agreement would normally require the investigator to assign their inventorship rights to you as their employer. As I said when we went through the slides, the inventors are always the owner of the patent unless they are required to assign their rights to someone else or another entity. So that agreement should be made with your inventors before you even consider a collaborative research program with another entity or with the federal government. And once you have that, then your agreement with your collaborating university or foundation or corporation will state right in the agreement who owns the inventions and what do you do if there's a joint invention. It is very, very typical and normal if you have a collaborative research program between two entities, between two different types of researchers. It is not unusual at all that you would end up with a joint invention, two separate owners, multiple inventors, and all that should be decided prior to the beginning of a collaboration. And that would be based on your policies.
And another question is, what recourse does a tribe have if they had agreed with the researcher that they would share in any outcomes of the research, but then the researcher goes off and just does their own thing and never talks to the tribe again? What is is there only recourse at the stage of applying for the patent, or is there recourse at the stage of the tribal research laws where they could enforce it? What's the best thing for a tribe, would you think?
Again, a very important question. Your first recourse would be, you first have to consider your policies. Are your policies clear that the inventor is required to assign their rights to you? So that's your first step, and that step should probably be taken before you consider a collaboration. Unfortunately, I can also tell you it has occurred in the past, infrequently, where a researcher, knowing these obligations and who have signed an agreement, they have to usually sign an agreement that they understand this policy and requirements. Sometimes it occurs that the researcher will go off and try to patent it themselves because they're the inventor. And then you may have separate recourses. Are they still contributing to your research program? Or, there are other ways to enforce your policies, as well as if you have a signed agreement, then there are actions within the patent office to assert your rights. Now, it's long and involved if you get that far, and hopefully, and in many cases, if it's the federal government and say my office learns of a situation like this, we will step in, because the government rights in any patent or invention that was paid for in part or whole by federal funds, we would have certain authorities to do that. It can be complicated, but again, the most important thing is to look at your mission statement and your goals so it's clear. There's sufficient training with your researchers. You're there to answer their questions and be supportive, and that your policies are clear what their responsibilities are and what your responsibilities are. So there are legal actions or other kinds of enforcement actions that can be taken.
The other aspect is if there's an agreement, say, between the research university or foundation and a tribal group to collaborate, and let's say the tribe feels that after the invention is made and how it's handled is not within the appropriate terms of the collaboration agreement, then usually the lawyers who have worked on these agreements have clauses in the collaboration agreement, explaining what will happen if one party or the other feels that a small or a large part of the agreement has been breached, has not been held up, the bargain hasn't been held up. So that might involve the principals of the two groups trying to work it out, talk through it and see if they can resolve it. Or you might, it might say that there'll be arbitration and you'll be appointing people to speak, to negotiate on your behalf to resolve the difference before, hopefully not, going to court to argue about it.
Well, that's really important to know that there are options to be able to address this if a researcher runs away with the invention and tries to patent it. So that's good. But the primary way, as you're saying, to prevent it is tribes should have policies in place and research laws in place, because the common rule actually says that if tribes have research laws in place, then the researchers have to follow them just like they would state or local laws, and that consent can be broader for tribes as well. And that gets into another question. We had a question on broad consent. The common rule allows broad consent to be put in consent forms, which means that, the data could be used for other things. But is it possible that if someone agrees to broad consent in their consent form, that does that relate at all to the invention and patent intellectual property issue, or does that would that have to be you could still protect that separately?
Right, they're separate, but they would overlap to the extent that the patent involves the use of the data or the use of materials that have been collected. Let's say blood cells that have been collected from a patient, and the invention involves the use of those for particular kinds of therapy or drug that's produced by them. Then it would be involved, but generally they're separate issues, and the patent would be treated separately from. So somebody might have patent rights, but they may not have rights to use materials or data in a particular way. So depending what the issue is, one could trump the other.
Right. Okay, great. Thank you.
And
Another question, what's the difference between a patent and a copyright?
There's a big difference between a patent and a copyright. First of all, there's two sections in the U.S. law in any international country. A patent law, there's a slide. It needs to be novel. It needs to be useful. And a copyright, and a patent does not protect written words, a dramatic work, or a publication. And those items I mentioned, those are protected under copyright law. The patent law is 20 years, and you get the right to exclude others from making, using, and selling. Under copyright law, it's 80 plus years for protection. However, someone can make a derivative, a change. If you're talking about software and code, they can make changes to the code, and they would end up owning the changes, not the beginning of your code. So if you have your original code or your original publication and someone makes changes, their changes are referred to as B, they would only own that section B, and the original owner would own A. So again, you would end up with multiple owners if you're talking about commercializing code that has come from various sources, various individuals, or materials. It often comes up when you're pulling different types of materials together. You would have one owner for material A, one owner for material B, one owner for material C, and you would end up having three owners if all the materials are pulled together.
I just also wanted to point out briefly that the data and the facts associated with them are not protected by copyright. The form in which it's presented is. So let's say you see an article in a magazine or a journal and it gives you some facts and figures. The facts and figures are not the facts, the numbers, things like that are not protected by the copyright, but the words in which, how they're described or how they're displayed as in art or a chart, that's protected, but not the actual facts themselves.
Okay, great. One of our attendees asked a question about data sharing, and I have to admit I'm a little confused why it came up towards the end of the presentation, why that relates to patents. Can you draw that link again just briefly to why data sharing relates to this patent issue?
They're separate issues, but they might interact, just as an informed consent might have an effect on how data is used and how a patent might be utilized when it requires the use of materials or data that's been collected from patients. So in a similar way, the data policies affect if someone has, say, NIH funding to conduct research. The policies on data deal with how that data, how the government and NIH expects the data to be shared with other researchers, especially. So understanding, and so there may not be a patent coming out or a new invention coming out of a research study, but there's nearly always data that's coming out of it, and so you might want to protect how that data is used in that context and understand how it can be used if there aren't further restrictions by the participants.
Oh, so for example, a tribe could agree that the researcher could do the study and the data, and then there's data that gets shared with another investigator, and maybe the other investigator creates an invention somehow, and it's like once removed from the original agreement. So the tribe needs to have a law that says any use of the data. If they want a patent, then they have to go back to the tribe, in addition to restricting use of data in general.
Well, that's a complicated issue because it's often not, it's maybe that data that's combined with lots of other data. So it's hard to tease out what part is from what party and what inspired, further follow-on research in data. Dave, were you?
Yeah, well, I just wanted to say I think the most important part about that conversation is the tribes engage in these agreements early on at the front end of the research endeavor and the collaborations. So there are no misunderstandings about where the data lies and who owns the data and how it's supposed to be properly used and handled.
Great. And the person that asked the question also wants to point out that the data sharing is an unresolved issue with tribes due to a prior lack of consultation. So they recommend we have more consultation on data sharing, but I can see how that can complicate talking about the patent issue because it's a related but complicated issue. So that's really important. The next question is, what efforts are underway at NIH to ensure biospecimens collected from tribes have appropriate approvals for sharing and dissemination, especially those samples collected before the policies mentioned in the presentation?
May I go ahead and answer that? Okay, great. This is Dave Wilson with the Tribal Health Research Office. I wanted to encourage any of the tribal members who are interested in that specific question to join us at the consultation with the All of Us research program. They are going to be collecting biospecimens as a small part of their research study. They do a lot more in terms of evaluating health, but I would really recommend those comments be shared with the All of Us program as their program begins to engage tribal communities to help shape how the program works effectively with tribal communities. And I think that kind of question is right now more on a program to program or investigator to investigator basis on how those agreements are worked out. But we're trying through our tribal advisory committee to establish more generalized principles that would reach across the agency and cover multiple research programs in terms of biospecimens handling and that sort.
And the last question is, what is the reason that NIH is wanting to consult on intellectual property? Is there any pending decision or possible change in policy, or what is, I guess with tribal consultation, what is it possible that input from tribes could influence?
Excellent question. So this is the Tribal Health Research Office was started in 2015, and I was appointed in 2017. So we are just a little over 2 years into this unique endeavor, and I think it's an opportunity for us as an agency to visit all the long-standing policies that may not be conducive to tribal nations involved or engaging in biomedical research. So we had a consultation early on around human subject protections, and the input from tribal communities led to some policies being changed around their participation and their identification as sovereign nations. We want to make sure that these policies are amenable for tribes to want to participate, and if there's something in there that inhibits or prohibits their participation, we want to know about it so that we can make adjustments or corrections, because the communities are a valuable part of the biomedical research endeavor, and we want to make sure that they have the opportunity to fully participate and fully reap the rewards that come from the world's largest biomedical funding institution.
Great, thank you. I know that's one question tribes will ask is, will our input result in anything? So it sounds like it's kind of an open-ended, let's review how it's done now and see if there's suggestions for change.
Right, and so I wanted to also communicate that we are undergoing a website revision and we're developing a specific tribal consultation page. So any consultation that is conducted by the NIH, any comments that are received by tribal communities, that we will post those on the website, and you will be able to see how those were specifically addressed so that your comments will not go unheard. They will be addressed. Thank you.
Great. I'm going to give all the speakers one more chance to mention anything else they'd like to mention or any other points you want to make for tribes in advance of the consultation before we end.
I just want to say that I think that this is a really important stepping stone on the path to successful biomedical research. And if there are any tribal leaders or members of tribes who can think of maybe what would be the next logistical step in terms of consultation so that we can improve our policies at the agency to better serve tribal nations, and please share those recommendations with us, and we'll look forward to seeing you all in person at the mid-year conference.
Well, thank you so much. And this is such a critically important topic. I hope everybody who's been on this webinar today or who are listens to the video can share the link once it's posted, because this is critically important to make sure that, you know, tribes benefit from any inventions or things that result from research that is conducted in their communities. And I would encourage tribes to engage your lawyers who are familiar with these issues as well to kind of take a look at it and comment as well. And so again, my brain hurts a little bit, but I think I might have to watch it another time to really get the information. But this has been really helpful to bring up an issue that people might not have thought of as really important. So I can see that we're at the end of the hour. So I'd first like to thank all of our speakers from the National Institutes of Health for their very informative presentation and willingness to join them today. And I'm glad they joined us here in person at the NCAI Embassy of Tribal Nations. And I'd like to thank everyone who joined the webinar today. Please don't forget to complete the feedback form that you will receive in the follow-up email after this webinar. And this webinar will be available as a recording soon on our YouTube channel that you can access from our website. Feel free to send the link around to any of your colleagues who may be interested. I have two announcements before we leave today. The first is watch for announcements for future webinars in the NCAI Policy Research Center monthly webinar series. We try to do them monthly, and the date varies based on the speaker's availability. I tried to do the fourth Thursday of the month last year, but it didn't work. So watch our website, our Twitter, and if you're not on our listserv, email research@ncai.org and we can add you. And save the date. Join us for our NCAI Mid-Year Conference and the 14th Annual Tribal Leader Scholar Forum at the NCAI Mid-Year Conference in Reno, Nevada in the last week of June 2019. The Tribal Leader Scholar Forum will be on June 26th on the Wednesday, and we just notified speakers, and we have a great agenda that we'll release in about a week or two. We hope to see you all there. And as Dr. Wilson indicated, there will be a consultation session on this topic at the NCAI Mid-Year Conference on Monday, June 24th, 2019. NIH will do the formal announcement of that, but it's starting at 9 a.m., so make sure you arrive on Sunday so you can be there right on time. Please encourage tribal leaders to attend and make sure everybody views this webinar before attending to get the background information you heard today. Again, as Dr. Wilson also mentioned, there will be a consultation on the NIH All of Us research program in the afternoon on Monday, June 24th, and we're hoping to hold a webinar in closer to the date, probably in May. And I want to make sure you all go there because that's a really important one too. And if you need to learn about that, we have a policy brief on our website in our publication section that you can review. And finally, we're doing our holding space training to strengthen tribal academic partnerships and playing the Tribal Research Futures game on the afternoon on Thursday, June 27th. You can find registration information for the NCAI Mid-Year Conference, and the agenda will be available on the NCAI website, www.ncai.org, and our NCAI Policy Research Center website. Again, thank you all so much for joining us today. Goodbye, and have a great rest of the week.